Welcome to another episode of Source Selection Soundbites. Today's topic is about understanding the acquisition laws of ambiguity. An ambiguity exists where two or more reasonable interpretations of the terms or specifications of the solicitation are possible. Ambiguities are harmful because they may violate a foundational rule of government procurement that states a solicitation must be drafted to enable offerers to intelligently prepare their proposals. The solicitation must be sufficiently free from ambiguity so that offerers may compete on a common basis. The key phrase being sufficiently free of ambiguity. On balance, the solicitation need not be totally free from ambiguity to intelligently compete. Next, let's discuss how issues of ambiguity are resolved during bid protests. A judicial forum's reaction to an ambiguity in the solicitation depends on the type of ambiguity that it is. There are two types of ambiguities. There are latent ambiguities and patent ambiguities. A patent ambiguity exists where the solicitation contains an obvious, gross, or glaring error, while a latent ambiguity is more subtle. If an ambiguity exists, the Government Accountability Office will determine whether the ambiguity is patent or latent in order to determine whether a protest was timely filed and the action that it will take regarding the ambiguity. A patent ambiguity, which is considered to be apparent from the face of the solicitation, must be protested prior to the closing date for submission of proposals to be considered timely. What's worse for contractors is that the contractor's interpretation of the patently ambiguous term cannot prevail once the solicitation closes. The patent ambiguity works against the contractor. Therefore, it's in the contractor's best interest to drive out patent ambiguities so it can be sure of the government's interpretation and improve its ability to effectively compete. A latent ambiguity presents more problems for the agency because the contractor has no need to protest them before the solicitation closes. The latent ambiguity, because it's subtle, only becomes evident in the context of an evaluation. Where there is a latent ambiguity, the appropriate course of action for an agency is to clarify the requirement and afford offerers an opportunity to resubmit proposals based on the clarified requirement. That is, when a latent ambiguity is discovered, the contractor is likely to prevail in a protest. In this instance, the agency should be sure to eliminate ambiguities to the maximum extent possible. In this episode, we discussed the definition of an ambiguity, patent and latent ambiguities, the differences between them, and the way they are officiated in bid protests. This concludes this episode of Source Selection Soundbites. If this video was helpful, hit the like and subscribe button to ensure you don't miss any new material. If you want more details on the subject, they are available on the Source Selection Answer app. It contains lectures, quizzes, court cases, sample documents, and more material that allow practitioners to quickly obtain actionable knowledge. Thanks for watching. See you next time.